Hello, this is Brenton Harrison of New Money, New Problems, and your host for the New Money, New Problems podcast. If you've been following our series, you probably tuned into this episode thinking that this is going to be the last episode in our series on pivoting mid-career into entrepreneurship. There are a couple of different things I want to do with the last episode that, to be transparent, I just need more time to complete. So we're pivoting a little bit for this week's episode, and I decided that what we're going to do is we're going to share a snippet from the webinar we did a few weeks back with attorney Jennifer Williams of Cedar Counsel. We got a really good response from it. So I thought it would be helpful to take a portion of that webinar and let you hear some parts that I think will be helpful. So in this snippet that you're going to hear, the first part is Jennifer and I asking each other questions that we hear in our various industries. So I'm asking her questions about estate planning that I hear from clients. She's asking me questions that she hears about financial planning from her clients. And then I share 5 ways that your financial advisor can help complement your estate planning attorney's work. So after I stop talking, you'll hear our voices again as a snippet from that webinar. It's just a snippet, but if you want the full replay, that's available as well. You can go to newmoneynewproblems.com/house in order. Once again, that's newmoneynewproblems.com/house in order. There's no fee for the replay. It's just something that we want everybody to have because we think that everybody needs an estate plan, no matter how well or unwell you think you're doing. So I hope you enjoy this snippet from the podcast.
Okay, so Brenton, this is the point where you and I are going to ask each other some questions here.
Yeah, so we each kind of have a question or two that we're going to ask of each other, and then I'm going to share some of the ways that a financial advisor helps in the estate planning process. So, Jennifer, you actually teed it up quite nicely. You talked about a trust being able to bypass probate. So, my question to you is, can you share a little bit more about how a trust works? And is there a reason why everybody wouldn't do a trust?
Sure. So let's talk about first what are the differences between a will and a trust. Because many people will come to me and they'll say, I have a will, so my family doesn't have to go through probate if something happens to me. And the truth is, a will must go through probate. It needs to be authenticated by a judge. A will is a relatively simple and short document as compared to a trust. A trust is a longer and more complex document where you're planning for several potentialities. For example, if X happens, then we do this. If Y happens, then this is the plan. So it's longer and more complex because it's dealing with many different scenarios that can take place. A will is effective upon death only as compared to a trust. A trust allows you to do this. You're creating this document, that's your trust, and you are what's called a trustee of your trust. And if you're married, you and your spouse are joint trustees of your trust, which means you manage all of the assets in the trust, your home, your bank, any of those assets. And if something happens to one or both of you, if you're married or if you're single, if something happens to you, then you are able to nominate a person called a successor trustee. And this is the person who will manage the funds in the trust. So what happens is this, a trust bypasses probate court because you've already written down what you want to happen. And a way that a trust works is that you must fund assets to the trust. And that's telling the government these assets should be distributed and handled according to the terms of this document that I've written. So, your home, I'll use myself as an example again. Carlin and I have a trust. We would not own our home as Carlin and Jennifer Williams. We would own our home in the name of our revocable living trust, right? And that just signals to anyone if we pass away or we become incapacitated, the rules that are set out in this document now apply. We don't need court intervention to tell us what's going to happen. We've already gone through a lot of different alternative scenarios, and we have made the plan ourselves. So And to the second part of your question, should everyone establish a trust? It really depends on your goals. I would say that you might think a trust is only for a wealthy person, but the truth is, if you own a home, if you have minor children, if you own property in multiple jurisdictions, it makes sense to consider a trust. I would say at least have a conversation with someone. I'm really not the attorney who will sell you on something or say, this is how I think it must go. I really want you to convey to me your priorities, what's important for you and your family. And then we go from there. So the second answer is it depends. But I would say you might be surprised to find out that a trust really would probably be the most effective estate planning vehicle for your family.
Nice.
No
Did you
problem.
have a
So I was
question
going to
for
ask my
me?
question. Yeah. So I have a lot of clients, and some of them may be on the line, but I have many clients who will come to me and they are planning for their, or they're working along with me and their aging parents. And they'll have a lot of questions for me about long-term care insurance, or does it make sense to create this type of estate plan if we want to qualify for Medicaid down the line? Or is it too late to put any long-term care insurance in place? And I always want to ask you about that. So I'm glad I can do that now.
Sure. So first, let's talk about, the difference between Medicare, Medicaid, and what long-term care insurance actually is. So Medicare is something that's age-based. You reach a certain age or disability status, and you're eligible for Medicare, regardless of financial status. Medicaid is needs-based. So you have to either be impoverished or impoverish yourself before you are eligible for Medicaid. So a lot of the things that people underestimate when it comes to someone, becoming older are the costs that are associated with that process, right? It's like such and such needs help around the home, or they need to go to a facility, and you find out that a facility that's just clean, maybe not even the nicest facility, is $3 or $4 or $5,000 a month. And the next step is, if we can't afford it, maybe we can apply for Medicaid. And if you're not working with a financial advisor and estate planning attorney, you see people take these steps that they think will make it easier to become eligible or have their parents become eligible for Medicaid. One of the things that they will do, because Medicaid requires you to have a certain amount of assets or less, is they'll try to transfer assets from their parents' name into their name. You can't do that. There's a look back period where Medicaid will say, hey, within the past 5 years, any transfers from this person who's applying to a child or someone of that nature is still considered a part of their estate. So they have to spend down those assets or sell them outside of the estate and use those funds for their care before they're eligible. In most cases, and it can vary by states, Medicaid, in order to be eligible, that person can have a house, a car, and in most states, $2,000 to $5,000. That's it. If they have a pension, it has to be spent towards their care. Any investment accounts have to be spent towards their care. What long-term care insurance does is it comes and it puts a fence around those assets so you can keep more before you apply for Medicaid. So for example, if you have a qualified long-term care insurance policy and there's all these metrics that you have to hit for it to be qualified, you may have a policy that in total provides $100,000 worth of benefits towards things like in-home health care, towards things like an adult daycare facility or a long-term care facility. So if I have a policy that covers $100,000 and I blow through the proceeds of that policy, I spend it all. Now I can apply for Medicaid, and instead of a house, a car, and $2,000, I can keep a house, a car, and $102,000. They have put a fence around all of the assets that I tried to protect by having a long-term care insurance policy. So it puts you in a position where hopefully your family doesn't need it, but if they need it and they blow through it, you don't lose all recourse in terms of saying, oh man, we had this inheritance, however big or small we may think it is, but we lost it all because we had to get care for my mother or my father or my aunt or my uncle. So if your parents are in good enough health to qualify, and even if the family can split the cost to get them even basic coverage, you are putting a fence around those assets in terms of preserving the asset and their Medicaid eligibility.
That's super helpful. Thank you. It's I want to bring it up because many of us are in that like a sandwich stage of life where we might be raising young children at the same time as caring for aging parents. So this has come up quite a bit, and I wanted to also um, just address one thing that you said. Is many of my older clients will say to avoid probate, and to, maybe avoid going through an official estate planning process, they will say, well, what if I just put my home in my adult child's name? And yes, that will avoid probate. But there are other considerations that you should know about. There are tax implications of doing that. There are gift tax implications, um, capital gains tax issues. So when that adult child goes to sell the home, if they ever do in the future, they will have to be concerned with tax issues. Capital gains tax isn't specifically. So it's important if you're going to make moves like this. I've seen a lot of people come to me with things that they've already done, trying to DIY an estate plan. And again, I think that that has its place. There are a lot of things that you can do before talking with an attorney. One is making sure your beneficiary designations accurately reflect your intentions, but make sure that you at least speak with an attorney, especially when you start, changing ownership of your most significant asset, with which for most of us is our home. So I just wanted to say that real quick before we.
You actually teed me up perfectly. So
Okay, great.
if we go to the next, I'll actually start with that. It wasn't number one, but we'll make it number one while it's fresh on people's minds.
Okay.
So these are some of the 5 ways that a financial advisor, a tax professional, because it's not just financial advisors, support an estate plan. Because you want to make sure that you have a relationship with your attorney where you have laid out all of these issues, laid out all of these concerns, but then you take that document and you keep living your life. And your estate planning attorney, if you don't make them aware, is not going to be aware of some things that could counteract some of the plans that they've made or some changes that might require them to update the plan. So here are 5 ways that a financial advisor helps support that estate plan. And we're actually going to start with coordinating tax and investment considerations, because that is what Jennifer was talking about when it comes to things like transferring property. So Jennifer, I'm actually going to pull up a whiteboard and I'm going to share with the people tonight one of the ways why doing things like, oh, I want to make it easier on my son or my daughter or my niece or my nephew to inherit this property can go sideways if done improperly. So we are going to assume in this scenario that we have a person who has a home that is worth $200,000. And they are going to, with best of intentions, say, if something were to happen to me, I'm getting older, I want to make sure that my son can access this property easier upon my death. I don't want to have to go through probate. I don't want to have to worry about it. So they transfer the deed of this property to their son. What they are failing to understand in doing this is there is a tax term called cost basis. And cost basis, for lack of a more simple explanation, is a tax term that the IRS uses to determine if you have an investment gain, how much you should pay taxes on. And they use that cost basis to calculate that number. Now, what happens with property or with investments is if you pass investments or property upon death, then the person who receives it inherits the basis at the fair market value of death or 6 months after. What does that mean? Let's assume that this home had no mortgage. And on the day that you die, it's worth $200,000. Well, if you waited until you died and passed that property at death, then the person who receives it is going to have a cost basis of $200,000. It's the fair market value at death or 6 months after. Now, if this person turns around and sells that property for $200,000, they sold it for $200,000 and they had a $200,000 cost basis. So in terms of taxes, there is no gain. But if you pass that property before you die, then that basis that they receive is your basis. So if your cost basis was $0 and you transferred this property before you died, then now your recipient's cost basis is $0. So if after you pass, they turn around and sell that property for $200,000 fair market value, they have a $200,000 taxable gain when they could have had a taxable gain of $0. This is an example of someone doing DIY when it comes to property, right? I didn't ask Jennifer whether I should transfer that property to my son. If I had asked her, she would have said, no, don't do that. Transfer it to the name of your trust. And then the trust can transfer it to your son upon your death. But by doing it yourself, you put your family in a position where now they're having to pay tens of thousands of dollars of taxes potentially on something that would have had no tax at all if done properly. So one of the things that a financial advisor or a tax professional does is when you're not in front of the estate planning attorney, and you are meeting with your financial advisor on that quarterly or semi-annual review, and you're talking about that transfer, we can say, absolutely not. Do not do that, because you're going to cost yourself or your family an arm and a leg by not understanding how the cost basis works when it comes to facilitating your estate. So that's it wasn't number one, I think it was like number 4, but that's one example. Can you pull back up the list for me, Jennifer?
Yes. Here we go.
The first one was structuring ownership and beneficiary designations. And when Jennifer was talking about assets that bypass probate, she said something that was very profound. She said jointly owned property, if structured appropriately, can bypass probate. But there's many different structures for how you can set up a joint investment account. One of them is joint tenants with rights of survivorship. That would definitely bypass probate, because what that means is you are both equal and undivided owners of an investment account. So if I own an account in that structure with my wife and I die, there's nothing for her to do because she was already the 100% owner. But there's also a type called joint tenants in common. So for example, if I started an investment account with a friend of mine or with my sister and we wanted to do some investing together, what that means is now we can stake out ownership percentages. Maybe I'm 50% owner and she's 50% owner. But if I have not put a beneficiary for my 50% and I die, that's not my sister's half. That's my estate's half. And I have now passed without declaring to whom it should go. So you want to make sure, even with jointly owned property, that you understand the structure of it, and if necessary, have added the beneficiaries. So your estate planning attorney will say, list out all of your assets. But if you don't follow through after they've told you, here's exactly how you should title your beneficiaries, then the estate plan is not done. Even if it's not jointly held property, there are individual investment accounts that have no beneficiary designation. And then there are accounts called individual transfer on death. If you have a transfer on death account, you can own it in your name if your estate planning attorney says that that's okay. And you can just name your trust or your estate as the beneficiary because it has a listed beneficiary. But if you have an individual account that has no named beneficiary, then you would need to meet with your estate planning attorney to get counsel and say, do I need to put this account in the name of my trust? Or do I need to have it retitled so that it becomes an individual transfer on death account? So the estate planning attorney can give you counsel, but the financial advisor would be the one to walk you through the process of either adding those beneficiaries or changing the structure on the account. And that is the difference between having something that could have bypassed probate instead be included in your probate estate. The next one, implementing proper insurances. One of the things that people talk about when they see estate plan, as Jennifer mentioned, is, oh, I don't have an estate, right? I'm not going to owe estate taxes. I saw that you can have up to like $13 million before you have to pay federal estate taxes. But Jennifer, can you share the estate tax limit in Maryland?
Right now, it's $5 million for a single person, $10 million for a married couple. But Governor Westmore just submitted a proposed budget where that would be halved. So that means that a single person could distribute or pass on um, a little over $2.5 million before worrying about estate taxes. But that really isn't as much as you think when you're thinking about your retirement, your life insurance, your home value.
You
So
said
yeah.
it. Jennifer, if not held or owned by your estate or passed to your estate, does life insurance factor into that calculation?
It does.
It does.
Yeah.
So even if you have, $50,000 to your name at death, but you were a high income earner and you had a $2 million term policy and you had a home of X amount, you have an estate in Maryland, at least, that will be subject to estate taxation. So having a financial advisor who can coordinate with your attorney is very important, because I can tell you, I don't know offhand the estate planning limits in all 50 states, but I can establish a relationship with an estate planning attorney to know what it is in that state. And if we are signing up for a really big term policy or putting you in a position where we're recommending something that would subject your estate to estate taxes, we can work with that estate planning attorney to say, who should own this? Should it be a revocable trust or an irrevocable trust? Should the person be listed as the owner, or should the trust be listed as the owner? If the person is listed as the owner, should the trust be listed as the beneficiary? And we can work together to structure those policies in a way that actually serves you. The next one, we only have two left. Tracking personal changes that require a plan update. Jennifer mentioned one where there was an estranged father who received all of the life insurance proceeds. You want to know a huge one that we see more frequently than I would like? People who have listed their ex-spouses on their retirement accounts or a life insurance policy, but have remarried and have more children in that relationship. Or people who have named children from that prior relationship, but have not updated those beneficiaries to include children from their current relationship. So imagine being in a situation where you have an ex-spouse who is listed as a beneficiary, or if you have a child from a previous relationship, but you've since had another child or two other children, and they have been disinherited because of you not going through and regularly updating your beneficiaries as life changes. And if you're working with an estate planning attorney like Jennifer, there's probably going to be touch points where she says, hey, how are things going? Let me know if things are changing. But she can't do that with everybody. And if she's not aware of things that would definitely necessitate updating an estate plan, you're really leaving it on yourself to know. And it may not be something that you are readily aware of, but a financial advisor or a CPA or an enrolled agent or any other financial professional that sees you more frequently can say, hey, I know that this person was listed as a trustee or an executor of estate, but they've since passed. Is there language in the document to make sure that there's a successor trustee? Hey, I know that you, prior to this relationship, were planning on having your brother-in-law be the guardian of your minor children. But now you and your ex-spouse barely even speak to each other. Do you still want your brother-in-law to be the guardian of your minor children? It's those types of personal interactions and changes that can make sure that as your life evolves, your plan is updated and it evolves as well. And then lastly, ensuring that plan objectives are carried out. Jennifer, I'm sure you will agree with this. All of this stuff is very important. It is a lot of hand-holding. It is a lot of updating of paperwork, and it's a lot of ticky-tack stuff that no one wants to do. And the fact of the matter is, I tell people when they're my clients, if you're on the call, you're my client, you've heard me say it a million times, I can be a really good little brother, meaning that if an estate planning attorney tells you to do something, but there's 10 things that have to be done to complete the estate planning process, changing the ownership structure of an investment account, transferring a deed from your name into the name of a trust, updating beneficiaries on all your life insurance policies and your retirement plans at work, you have to either have the discipline to do it on your own or have a really annoying person who is lovingly telling you, hey, this is not done. We still have work to do to make sure that the plan is fully complete. So those are the 5 ways that a financial advisor can support an estate plan. And if there are questions, Jennifer, I think we have one more slide that we want to make sure we drive home the point. But as we drive home the point, please type your questions.
Yes, and thank you for bringing up when life changes, life events happen, it's important to make sure that your plan reflects your current reality, your life. I've seen many people's plans who they'll ask me to review it, give a second opinion and see if there's anything that needs to be changed. But there are several people who've passed away who would make medical decisions for them if they were incapacitated, but that person's no longer living or the relationship has changed. But the truth is that most people, sadly, don't have any plan in place. They have no plan. So if something were to happen, um, a judge would step in and make decisions for them, and that can cause a lot of heartache, stress. It can be expensive for your loved ones. So it's best to put an estate plan in place and to work with someone like Brenton, who's amazing, a good little brother who will make sure that the plan works when you need it to work. It's always good to have many pairs of eyes. And also with all of our clients, every 3 years, we take a good look at their plan. Or if there's a major life event in the interim. So even if you put an estate plan in place, or if you're not in my jurisdiction, if you're looking for an estate planning attorney, ask them how often they'll look at that plan for you. And we do it for free. People should be able to walk you through what they put in place for you on a regular basis.
From New Money, New Problems, this was the New Money, New Problems podcast, a show for successful professionals searching for the tools they need to navigate financial opportunities and obstacles they've never seen.